Good morning. Welcome back to our online classroom. This is the second half of the lecture. Okay, so if you look at the topic, we are still in a session on vitiation of will, the situations where the will of the party may be vitiated, and that will render a juristic act in question to be invalid. Okay, from our previous lectures, okay, we have seen many situations in which the will of the party may be vitiated. Okay, we have seen the situation involving a hidden intention, okay, or sondren, and we have seen the scenario in which, okay, a person has declared a fictitious intention or luang, and we have also discussed the situation involving a declaration of an intention which is fictitious and aimed at concealing another juristic act, okay, what we know as amprang or nidikam amprang, okay, and next we are going to talk about the situation which is concerned with fraud, okay, or konchon in Thai, okay. And if time permits, this morning we will also move on to discuss, okay, the principles of law regarding juris or gan kumku. But I don't think that the time is going to permit us to deal with juris this morning. Okay, so let's at the moment, okay, let's just focus on principles of law, okay, governing the fraud. Okay, so fraud or konchon, right? As we have seen that in order for a juristic act to be upheld, it must be a product of free will, right? So when the will of a party is not free or is not genuine, then that juristic act is not going to be given a legal effect or full legal effect. Okay, so in some cases it may be void, in some cases it may be voidable, as the case may be. Okay, so one of the situations which render the will of the party, okay, to be not free, okay, or to be not genuine, it is the fraud. Okay, so we are going to look at the nature of fraud. Okay, what is it when we talk about fraud? Of course, fraud, it is sort of an extension of a trick, a hoax, or in fact the deception or deceit. Okay, it is in the form of giving a false statement in a deceitful manner, okay, in order to induce the other party to enter into a juristic act. Okay, so let's suppose that we have again A and B, right? A and B, they have made a juristic act, let's say a contract. Okay, the thing is that A gives some statements to B, and this statement it is not correct. It is untrue, right? And A knows that is untrue, but A has sort of deceitful intention. Okay, a deceitful intention. A just give this untrue statement to B, knowing that it is untrue. Okay. This is made in order to induce B to enter into a juristic act, let's say a contract with A. Right. For instance, A tells a lie to B. B does not know the fact, the true fact, okay? So B, after being told of a lie by A, B believes in this statement, even though it is a lie. Right. So in reliance on this false or untrue statement, B just decides to enter into a contract with A. We can see that in this case, the false or the fraudulent statement given by A, okay, induces B, okay, to enter into the contract or into a juristic act with A. So in this case, okay, the juristic act in question, it is made by fraud. It is procured by fraud. So there is therefore no reason for giving full, the full legal effect to this juristic act. So in this case, when we know already that, okay, the fraud is in a way, okay, fraud takes the form of the two things. Okay, the first one is the fraudulent misrepresentation. Right, that means that one party, the first party, just gives an untrue statement to the other party, right? And that is made with some deceitful intention, right? So in this case, we can just say that fraud, it is the fraudulent misrepresentation. But one thing which I need to also bring to attention is that in addition to the situation where A tells an untrue statement to B, okay, in order to deceive B and in order to induce B to enter into a juristic act with A, fraud can also take the form of some concealment of some crucial facts. Okay, that means that A may not tell any untrue statement to B, but A knows some facts which are crucial, but he does not reveal this fact to B. He does not reveal this fact to B. If B, okay, let's say that B is induced by this fact, A believes in this fact. Even though A does not tell any untrue statement to B, but A knows some facts, but A does not reveal this fact to B. If B, in fact, just now I just try to say that that it is the giving of statement. In fact, A does not give the statement to B, but A knows some facts. But A decides not to reveal this fact to B. But if B had known this fact, B would not have made a contract or the juristic act with A at all. So, right, B goes ahead with this conclusion of the juristic act. Right, simply because B, at the time of the conclusion of that juristic act, did not know anything about that. If B known about that, B would not have made the juristic act with A. In this case, fraud can be in the form of non-disclosure. So if you look at this picture, you can see that fraud may take two forms. The first form is the fraudulent misrepresentation. Okay, this means that it is the giving of a false or untrue statement to the other party, knowing that that is false or that is untrue. Okay, but the one person, the first party, just gives this false statement to the other party in order to induce the other party to make the juristic act with the first party. That is fraud. Fraud in the form of fraudulent misrepresentation. Right, but the other form of fraud, it is non-disclosure. When a party knows some crucial facts, the facts which are so important, and that party does not reveal or disclose that fact to the other party. So when the other party does not know that fact, the other party just enters into a juristic act with the first party. So this is also considered as fraud, or we can just say that this is fraud by silence. See? So the two forms of fraud, right? But by way of caution, okay, that I would like to just let you know that with respect to the second form of fraud, it does not mean that all disclosure will constitute fraud. Right. Fraud by silence or by non-disclosure can just give rise to litigation or to a claim only when there are some special circumstances. We will talk about that later. Now, Should we begin with, shall we begin with the first one? Okay, fraud in the form of what? Fraud in the form of, the fraudulent misrepresentation. Okay, but before I, begin discussion on the first form of fraud, let me just tell you one more thing. The possibility of overlapping between fraud and mistake. We can see that if we come back to the situation involving fraud, we can see that fraud, it is concerned with, it may be concerned with what? The act of what? The act of telling an untrue statement in order to deceive the other party to enter into a juristic act with the first party. Like when the A tells a lie to B, right? In this case, you can see that the decision made by B to enter into a juristic act with A, that is a mistaken decision. Okay, had B known the truth, then B would not have made the juristic act with A, so that the case of fraud is in some degree concerned also with what? With mistake as well. So that there is, the possible overlapping between fraud and mistake, right? When A tells a lie to B in order to induce B to, to enter into, let's say, the contract with A. Okay, B has, in this case, made the contract with A, or as a result of some mistake. The decision made by B is mistaken. So that you can see the overlapping between fraud and mistake. The thing is that in the law of many countries, of course, including in this country, in Thailand, we have both the principle of fraud and the principle which applies to mistake, right? Like for instance, in English law, they have the doctrine of fraud. They do not call doctrine of fraud. They call the doctrine of misrepresentation. Okay, in English law, there are both the doctrine of misrepresentation and the doctrine of mistake, so that the case, the facts concerned may fall within both the doctrine of misrepresentation and the doctrine of duress. In some countries, like in Thailand, in France, in Germany, the situation where A tells a lie to B, or A gives a statement to B which is false, and in reliance on such false or incorrect statement, B enters into the contract with A. When A knows that that is false, A just decide to give this statement to B, so that this is sort of fraudulent misrepresentation, right? We have in Thailand, or in some other countries, similar countries, we have the principle of fraud. And also the principle of mistake, given that in this situation, B has made a juristic act, maybe the contract, with A, due to, some mistake, because when B receives a false statement from A, B mistakenly decides to enter into the contract, right? So the conclusion of the contract, or the conclusion of a juristic act, it is a product of a mistake as well, right? That means that the same facts, the same set of facts may trigger both principles or both doctrine, the doctrine of fraud and the doctrine of mistake at the same time. That is theoretically possible, right? So when the same set of facts may trigger both doctrines or both principles of law, right? Then the question is, which principle or which doctrine can be called into play by the party? Well, the answer is that it is the choice of the party. The party can have choices. The injured party, the party who is injured, the party who suffers some grievance or some injury from the Juristic Act may choose the doctrine or the principle of law which best suits his or her own interest. Okay, if he or she think that well the calling into play the doctrine of mistake can just best suit his or her own interest, then fine. The injured party may go ahead with that principle of law, right? So they can just choose the doctrine which best benefits that party. Okay, so that is something possible. So now we begin with the fraud. Right, fraud. Remember there are two forms. Two forms of fraud. Remember, fraud in the form of giving an untrue statement or giving a false statement to the other party, knowing that that is false. Okay, so the giving of that statement, it is made with some deceitful intention. Okay, that is fraudulent. Okay, the misrepresentation. Okay, and fraud may take the form also of non-disclosure or silence. Okay, in our CCC, okay, our CCC just classifies fraud into even three types. The first one is general fraud. Okay, the second one, it is called incidental fraud, or in Thai we call this one คนช่อชนเพื่อเหตุ. And the last one, of course, is a fraud in the form of non-disclosure, fraud by silence. Okay. Right. Now we are going to consider these three types of fraud in turn. Okay. As I have mentioned, okay, for the last type of fraud by silence or fraud in the form of non-disclosure. Okay, it can give rise to an action. Okay, an action in court only in special circumstances only. That will be explained shortly. Okay, that now should we begin with the first type of fraud in our CCC, general fraud. Okay, what is it? General fraud, of course, it is a fraud. Okay, it is a fraud without which the other party would not have entered into the Juristic Act at all. Okay. Let's say that again we have A and B. Okay, let's say A gives some false statements to B, and B believes in those statements. So the B is in a way induced by those statements, and B enter into, let's say, a contract with A. If B had known the truth, then we would not have made a contract on the Juristic Act. Okay, so this is general fraud. Fraud in general, fraud without which, okay, the other party, in this case B, okay, would not have entered into the Juristic Act in question at all. Let's suppose that we have this case as an example. Okay. We have again A and B. Okay, A and B. This is A and this is B. Okay, A, he has, let's say, a lot of land, but this lot of land is indeed located in a very remote area. Okay, it is in Bangkok, but it is a suburb of Bangkok. Let's say it is in Nong Chok. You know Nong Chok, right? Nong Chok, it is a very poor. It is a rather poor area of Bangkok. In fact, it is quite far. Okay, so normally in lands there, it is not quite well developed. Okay, and land there seems to be quite, seem to be of quite lower prices. Okay, so that you cannot sell your land at a very high price if your land is in this area. Okay, which is the suburb of Bangkok, right? It is in a suburb of Bangkok. Let's suppose that A's land here, it is worth only 800,000 baht, right, just 0.5 million baht. But A wants to sell this land at a much higher price. So A just wants to tell a lie to B. When A meets B, A tells B, oh B, you can just buy this land, okay? This land, even though it is in a suburb of Bangkok, it is quite far away, but it has some rich, economic minerals. If you buy this land, you will be very proud because you can just exploit this land very much due to the presence of some economic minerals in this land. And let's suppose that after having been told like this by A, B believes in this statement. So B just decide to buy this land from A. Okay, A just sell this land to B at the price of 5 million baht. In fact, if A had not, let's suppose that the contract of sale was made. If A had not told this lie to B, this untrue statement to B, B would not have bought this land. Who would buy this land, for 5 million baht when this land would be worth only, the 0.8 million baht, right? So in this case, had been known the truth, B would not have made this contract with A at all. So this is a fraud in general. Remember, it is a fraud without which the other party would not have made the Juristic Act at all. If the other party had known the truth, the other party would not have concluded the Juristic Act in question at all. Right. So now we are going to, the one more example. Let's suppose that we have this painting. Let's suppose that this painting, it has been by a very the famous, in fact, nationwide famous artist in this country, Master Chalerm Chai. I'm sure that you know this person, okay? The very famous artist, right? If he just draws any the painting, any picture, then that work, can cause maybe many thousands or tens of thousands baht, or even a million or several millions baht, right? The thing is that in this case, A, he had this painting, and he knew that this painting was not by Master Chalerm Chai at all, but he bought this painting from the Sunday market. He bought it only for 1,000 baht. He wanted to sell this one at a much higher price, right? Of let's say that 100,000 baht. So he told a lie to B that this painting was by Master Chalerm Chai. Right. When B believed in this lie, B decided to just buy this painting from A. Right. So the contract was made because of the reliance on the part of B, B's reliance on A's false statement. Okay, so that if B had known the truth, B would not have made this contract at all. B would not have purchased this painting at all. So this is a fraud. This is the fraud in general. Okay, general fraud. The fraud without which the Juristic Act would not have been made. Right. So now when we know the nature of this fraud, when we know the nature of general fraud, then what is going to be the consequence of this kind of fraud? The consequence of a Juristic Act which is procured by this kind of fraud is that the Juristic Act is just voidable. See, this is the rule in section 159 of our Civil and Commercial Code. Okay, 159 provides as follows. The declaration of an intention on account of fraud is voidable. See, we have in the case of the hidden intention in the case of fictitious intentions. We have seen just the word void, right? The Juristic Act will become void. Right. But in the case of fraud, then the Juristic Act in question will become voidable. Or in Thai, more clear. What is that? The word voidable means this. When a Juristic Act in question is merely voidable, this means that, okay, it remains valid until the one who suffers injury, until the one, who is injured, avoids it, until the one who is injured avoids it. In Thai we call บอกลา avoids means making it void. At the beginning, it is not void, but the one who suffers some injury will later avoid it. The one who suffers some injury will just make it void. Maybe by declaring, by alleging that it has no effect. It is of no effect. Right. So, when the Juristic Act in question is voidable, it is not void. It is not void ab initio. It is not void from the beginning. It remains valid. Let's say that if A and B, made a contract like this, okay? If A and B made a contract, right? Let's say B purchased something from A in reliance on the false statement given by A. The contract is voidable. This is a voidable act. โมคียกรรม Right. So B has choices. B can say, fine. The thing is that the law say that this remains valid until it is avoided by B. So B, let's say that B, just now we talk about the case where A sells the land to B at the price of 5 million baht, but the B has purchased that land because of a lie told by A that the land is full of some economic minerals. If the land has nothing at all, that land is going to be worth only 0.8 million baht. But A has told a lie to B about the presence of economic minerals, so that B decided to buy this land from A at the price of 5 million baht. In this case, the contract in question, the Juristic Act in question will become voidable. It remains valid until it is avoided by B. So, if B said, fine, even though I have purchased this land from A for 5 million baht, even though it is worth only 0.8 million baht, but A is just my friend. I forgive my friend. I now forgive my friend for what he has done wrong. Fine, I will do nothing. So if B does not avoid this contract remains valid. Or B can just ratify it. ให้สัตยาบัน okay. B can just ratify this contract. If B give ratification, then it will become valid forever. Or B can just avoid the contract or the Juristic Act. In this case, if B avoid this contract, it will become void ab initio, even though at first it does not become void, but once B avoids it, it will become void. Okay, it will be treated by law as being void ab initio. Ab initio means from the beginning, ตั้งแต่แรก Okay. So this is the consequence of the law. Remember, in the case of fraud in general, the legal consequence of the Juristic Act is that it will become voidable. So that the party who suffers some injury may just avoid it at his own election. Okay. So from the two examples which we have drawn just now, remember the example number 1 and example number 2. in the example number 1, which is concerned with the sale of land. In this case, B bought the land from A at the price of 5 million baht. Right. Because B relied on the fact, the false fact given by A, the fact that, the false fact that the land contains some, the economic minerals. In this case, the contract between A and B has become voidable, so that B, the purchaser, B can just avoid this contract. How can B avoid it? Well, B may just, let's say, B may send a letter, or B may send an email telling you that now B wants to just avoid this contract, which is procured by fraud. See? So once B decides to avoid it, then that contract will be regarded by law as void ab initio. Okay. Or in the example number 2, when B has purchased the painting in reliance on the false statement given by A that painting has been by Master Chalerm Choi. In fact, okay, it has been acquired by A from the Sunday market at the price of just 1,000 baht. In this case, B can just avoid this contract, okay, by writing a notice to A that now B does not want to be bound by this contract. B wants this contract to come to an end. Right. But for one thing, okay, in the case of fraud in general, the party who is injured, okay, the party who suffers some grievance can just claim that the Juristic Act in question is voidable on the ground of fraud only when there is the presence of some element of inducement. This means that a false statement given by A, okay, induces B to enter into the Juristic Act with A. If the statement, even though it is false, even though it is fraudulent, if it does not in any way induce the representee or the other party, okay, at all, then the Juristic Act in question will not become voidable. Right. This is the consequence in section 159 paragraph 2. Okay. 159 paragraph 2 goes on to say this: an act procured by fraud shall become voidable under paragraph 1 only when it is to such an extent that without the said fraud such voidable act would not have been made. Okay, without such voidable act, without such fraud, okay, the voidable act would not have been made. Right. This means that the fraud in question must have induced the other party, okay, to enter into the Juristic Act in question. Right. We have this example. Let's suppose that we have again A and B. Let's suppose that when A he has a diamond ring. Okay, he sold this ring to B, and he told B that this diamond ring, it was made of genuine diamond from South Africa. When people are told that the diamond is from South Africa, then people will trust that diamond will be of premium quality because South Africa is very famous for diamond. Okay. So in fact, in this case, when B was told by A that the diamond was from South Africa, B did not believe in this statement at all because B happened to be an expert in precious stones. So B knew that no, this diamond is not from South Africa. This diamond may be from Myanmar. It is most likely to be from Myanmar, not South Africa. Okay. But even though B knew this fact, B nonetheless decided to buy this ring from A because A sold this diamond ring at a rather low price. So B wanted to take the benefit of this low price. So B bought this ring nonetheless. We can see that the fraud in question, the fraud given by A, did not in any way induce B at all because B knew the truth. And B wanted to buy this ring nonetheless. See, without this fraud, B would nonetheless buy this ring. So in this case, when there is no element of inducement like this contract, this jurisdiction between A and B cannot become voidable. That's why section 149 paragraph 2, makes it clear that an act procured by fraud shall become voidable under paragraph 1 when it is to such an extent that without the said fraud, such voidable act would not have been made. Right there. If A had not told the lie to B, B would not have bought this ring at all. But in this case, even though A told a lie to B, B would nonetheless buy this ring because B considered this ring, diamond ring, as worth buying. Even though B knew the truth about the source about the origin of this diamond ring, right? Now, just now we talk about the contract or the jurisdiction made between A and B because of A's fraud. What about the situation where the fraud is not by A? The jurisdiction is made between A and B, but the fraud in question was committed by somebody else, by a third party or a third person. Let's say that by C here. Right. We have, let's say, a jurisdiction or a contract between A and B. B enters into the contract with A, not because of the fraud given by A, but not because of the false statement given by A, but because of the false statement given by C. So this is fraud committed by a third party. What is going to be the legal consequence of fraud committed by a third party? Okay. If you try to say that, in this case, the B just enters into the contract with A because of the fraud. If B had known the truth, then B would not have made the contract or the jurisdiction at all. If the law just, sets the result that, the contract between A and B is voidable, will that be fair to A? Because A may know nothing about the fraud committed by C. So for this reason, because of the possibility that A might not know nothing about the fraud committed by a third person, that's why the law will have to do, we have to do justice to A as well. The law say that in the case of fraud by a third party, by this, the jurisdiction will become voidable only when the other party knew or ought to have known of such fraud, which were committed by the third party. This is, embodied in section 159, paragraph 3, of the Civil and Commercial Code. According to section 159, paragraph 3, if a party has declared an intention on account of fraud committed by a third person, the declaration of such intention becomes voidable only when the other party knew or ought to have known of such fraud. That means that in the case like this, okay, A and B, they have made the contract because of the fraud. The reason why B decided to enter into the contract with A, okay, is because C told a lie to B and B, okay, relied on the false statement given by C. So in reliance on such false statement, B concluded, let's say, a contract with A. In this case, right, it is the fraud committed by C, i.e. the fraud committed by a third party. We will have to look at, the knowledge of fraud committed by the third party, okay? We will have to consider the knowledge of the other party, the knowledge of the fraud committed by the third party. So in this case, we will have to see whether or not A knew about, the fraud committed by the third party. If A, okay, did not know anything about the fraud committed by the third party, A should be protected by law. The Juristic Act between A and B should not become, the voidable, right? So in this case, let's suppose that, that we have the facts like this, okay? We have the fact like this. We have A and B. A is the hotel business owner. Alright? Okay? Let me just drink some water. Because when I'm thirsty, okay, then I might mispronounce, some words so that the words may not be clear to you. Okay, so sometimes I'm sorry for mispronunciation because sometimes I get thirsty and when I cannot drink water on time, then it will just lead to mispronunciation. Okay. Right. Again, A is a hotel business owner. He wanted to sell his hotel business. Let's suppose that he had placed advertisements, maybe on the internet, okay, on some social media for many years, okay, but nobody showed any interest to buy his hotel business, even though A had attempted to sell this business, for a year or for a few, sometime for more than 1 year, okay. One day, B visited this hotel. So B came to the scene. So B, in this case, visited the hotel. Okay, and by chance, B just met. Okay, by chance, B just met C. C was just a stranger who happened to be there. Right? And C, when B met C tried to help A sell this hotel business. So C told a lie to B. C told B that this hotel had in fact received the ISO 9001 certification. In fact, this hotel had never been ISO certified at all, so that the statement given by C to B, that was apparently false. Okay, C just told this lie to B, of course with some deceitful intention. C wanted to help A. Right. So we have this situation when B believed in this fact given by C. B just decided to buy this hotel business. So we have a contract between A and B, a contract of sale of this business. the hotel business. Of course, I mean that this Juristic Act was procured by fraud, but not fraud on the part of A, but fraud committed by C, who is a third person. Right. Would the sale here, would the Juristic Act between A and B become voidable? Okay. Yeah. Would that be voidable? According to section according to the section 159 paragraph 2, which say an act procured by fraud shall become voidable. In this case, right, section 159 paragraph 3 realize that maybe the first party, in this case A, maybe the first party, in this case the hotel business owner, did not have knowledge of the fraud committed by the stranger or the third party at all. That's why section 159 paragraph 3, right, say that the Juristic Act in question would be voidable only when the other party, in this case the hotel owner, knew or ought to have known of such fraud. So in this case, if we are back to the facts here, we will have to distinguish, the facts into two scenarios. The scenario in which A knew or should have known of C's false statement, and the situation where A did not know and should have known of the fraud committed by C, who is a third party. If A knew or should have known of C's false statement, then A should be considered as the being at fault as well, so that there is no reason to protect A. Right. The Juristic Act, in this case the sale between A and B, would have to become voidable. But if it turned out to be that A, the other party, okay, we talk about the Juristic Act between A and B, which was procured by fraud, okay, committed by a third person. In this case, the law say that if the other party, i.e. here A, did not have knowledge and should not have the knowledge of the fraud committed by C, then A was not at fault, so that there is no reason to hold A liable. In this case, the Juristic Act in question would not become voidable. So the reasons seem to be very straightforward. I think that you can just analyze the reasons by reference to your common sense, okay? So this seems to be very, very sensible indeed, okay? Now, right, so just now we talk about, fraud by the third party. What about the fraud by both parties? When both parties committed fraud alike, A and B both commit fraud, okay? We can see that when both parties commit fraud, then they both are dishonest, so that the law should not protect them. Right. When the law should not protect them, right, that means that the juristic act between them should be voidable. Right? So, the juristic act between them, right, should not be voidable, right, because they both commit fraud on each other, so that they should not be protected by law. The law should not regard the juristic act between them as voidable. Right. That's why in section 163 it is provided as follows. If both parties have carried out any act by fraud alike, both parties will do the same thing, i.e. committing fraud, neither party may allege fraud on the part of the other party for avoiding such act or claiming compensation. So the law treats the juristic act as valid nobody can just allege that it is voidable. Nobody can claim any compensation. Okay, it is treated as if it were valid. Okay, we can just draw the. We can just give an example with respect to fraud committed by both parties. Let's suppose that we have in this case again A and B. A, he has a painting. B, he has the horse. Okay, B has the racing horse here. So A and B, they make an exchange. สัญญาแลกเปลี่ยน In Thai we call this one สัญญาแลกเปลี่ยน Okay. So the A will allow B to have, to have his painting, and B will allow A to have his racing horse. The exchange between the painting and the racing horse here. Both parties, let's suppose that in concluding this agreement, okay, the exchange agreement, both parties, both A and B just told a lie to each other. A told B a lie that this painting was by a very famous artist in Thailand. In fact, it was not by any famous artist. It was by a very normal artist with no reputation at all. Okay, and B, similarly, B told a lie to A. B told A that this racing horse won the first prize in a national competition. This horse won, a prize, the first prize he did in a national competition. Okay. In fact, this horse never won anything at all. You can see that both parties, they told false statements to the other party in order to induce the other party to to enter into this exchange. Right. So if B had known that this painting was not by the very famous artist in this country, B would not have concluded this exchange. Similarly, if A had known that this horse, had never won any prize at all from any competition, then A, would not have taken this horse in return for the painting from him. Right. So when both parties just committed fraud like this, when both parties committed fraud alike, the law does not allow anyone to claim that this contract was voidable, so that neither A nor B can avoid this contract, and neither A nor B can claim any compensation. Even though if they had known the truth, they would not have made this exchange. But there is no way out. No rescue by law, because both of them happen to be dishonest. So the reason seems also to be what? The reason seems to be also straightforward. When both parties just are at fault, when they are dishonest, they should not be afforded any protection by law. Now we are coming to the third type of fraud. Right. Incidental fraud. Or in Thai we call this one กลช่อชนเพื่อเหตุ What is it? Just now remember when we talk about general fraud, that is the fraud without which the Juristic Act in question would not have been made. But with respect to the case of incidental fraud, it is a fraud which is merely conducive to the acceptance of some more onerous terms. Some terms which seem to be harsh, which seem to be more onerous. Okay, let's suppose that the contract is made between A and B. Right. A told something false to B. If B had known the truth, B would nonetheless conclude this Juristic Act. but B would perhaps, okay, B would have accepted better terms or less onerous terms. So fraud in this case, it is just incidental fraud or กลช่อฉนเพื่อเหตุ So we can compare between the two types of fraud in general and incidental fraud, okay? With respect to general fraud, it is a fraud without which the Juristic Act would not have been made, okay? But in the case of the incidental fraud, it is a fraud which is merely conducive to acceptance of some more onerous terms. Right. Have a look at an example here. Let's suppose that we have again A, okay, and B. A and B. Let's suppose that A, he is very much interested in buying a second-hand car, second-hand Mercedes-Benz. Right. But A, he was so safety conscious. So safety, okay, conscious. So he wanted to make sure that the car, okay, was free from any any accident at all. Right? So he asked B, let's say B, in this case B had this car and B wanted to sell this car to A. A asked B whether or not this car had any accident. He asked B whether this car had any accident. B said no, not at all, not even a very tiny accident at all. In fact, the truth is that this car experienced a very, very serious accident. The accident which caused the death of even 2 people. Right. If A had known this truth, the thing is that when A was told by B that this is A, okay, this is B. When A was told by B that this car was free from any accident, this car had not experienced any accident at all, A believed in this statement. And B bought this car for 1.5 million baht on the basis that this car had no accident at all. But if A knew the truth, he would not less buy this car, but he would just give at most just 1 million baht as the price. If he had known that this car had an accident before, then A would nonetheless buy this car, but he would have offered only 5 million baht, not 1.5. See? So this is not the fraud in general, because the fraud in general, it is the one within which the party would not have made the Juristic Act at all. But in this case, it is the fraud which is merely what? Conducive to the party. It is conducive to the party, in this case A, okay, accepting some more onerous term, okay. It just led to A, the agreeing to pay 1.5 million baht rather than 1 million baht only. So this fraud, right, this incidental fraud just led to A, okay, the agreeing to pay 1.5 million baht, which of course, which is a more onerous term. If A had known the truth about the accident, A would have been willing to pay only 1 million baht. Correct? So in this case, it is the so-called incidental fraud. What is the consequence of this fraud? Simply because this kind of fraud, okay, is merely conducive to the other party accepting some more onerous term, okay, so that the other party just suffer some injury only, not full injury, so that the law allows allow the one who is, the one who receives the false statement, we call that one misrepresentee, okay? The law allow the misrepresentee to claim compensation only, not to avoid this juristic act, right? Right. Because if that party had known the truth, he would have concluded the juristic act. Okay, he would conclude that the Juristic Act only on a better or less onerous term. That's why the law allows him to allow that party to just claim compensation for his loss, not the right to avoid the Juristic Act. Right. So if we apply, the rule here, in fact, it is the rule in section 161 of the CCC. Okay. Okay. Maybe we have a look at this rule first, and then we go back to the example which we have seen just now. The rule in 161 is this one. If the fraud has merely constituted an incidental factor, okay, inducing a party to accept more onerous term than such party would usually have accepted, such party cannot avoid such act, but can claim compensation for damage resulting from such fraud. So, from the example above, the consequence is just that A, if we go back to example here, okay, when B told a lie to A about the accident, in fact, this car had experienced an accident before. If A had known the truth about this accident, then A would have offered, just 1 million baht as a price, not 1.5 million baht. So in this case, this is incidental fraud. Just led to A accepting more onerous terms. Okay, that's mean paying 0.5 in extra. Okay, paying 0.5 million. Okay, more than expected. Okay, so in this case, the law allows A to do what? Not to avoid the contract here, but to claim compensation. What is the amount of compensation entitled to by A? Okay, that in this case, the compensation should be given to A in an amount of, the 0.5 million baht. Okay, because A agreed to pay 0.5 million baht more. If he had known the truth, he would have been willing to pay only 1 million baht. Okay, so in this case, A could claim, the compensation in an amount of 0.5 million baht. Right? That is the consequence embodied in section 161 of the CCC. Okay. Now, can we say an example at least from the Supreme Court case? We have the Supreme Court case here. Supreme Court decision in 1988. Okay. In this case, my God, time seems to fly. Okay. Now we have a lecture for the second half of the lecture. Now lasts for more than 1 hour. Okay. So I have to just finish off this part of the lecture very soon to make sure that you can attend the lecture for another subject on time, right? In this case, we have the contract between A and B, right? The contract between A and B, the contract of sale. A, he sold his land to B, right? He sold the land to B, and A in this case told B a false statement. A misrepresented to B that this land was just, in fact, adjacent to the riverbank. A told B that, well, this land was here. This land is, the property was just next to the riverbank. It was immediately adjacent to the riverbank. But in fact, the land which was owned by A, it was not immediately adjacent to the riverbank. It was here, okay, it was interrupted by one more house here. So the land which is sold, it was not this one, but it was this one. This land was not immediately adjacent to the riverbank. It was interrupted by one more land here. Right. So, if B, the buyer, knew the truth. If B knew the truth that in fact the land sold by A was not immediately adjacent to the riverbank, B would have agreed to buy it. Of course, B would nonetheless conclude this contract, but B would have agreed to offer a lower price, not the price as demanded by A. In this case, it was held by the Supreme Court that it was incidental fraud, คนช่อชนเพื่อเหตุ So, okay, based upon the section 161, okay, based upon section 161 of the CCC, B, the buyer, was entitled to demand compensation for the excessive price. Right, so this is a real story drawn from the Supreme Court. Okay, now perhaps this is the final stage of this lecture, okay, or this topic. The last part, okay, fraud by silence. Right. As we have seen from my explanation at the beginning, okay, in addition to the situation where A tells a lie to B, A may not tell any lie, but A just keeps quiet. A knows some important facts, but A just keeps it. A just keep quiet. A does not reveal or disclose that fact to B. If B had known the truth, B would not have made that juicy act. So of course, this is the fraud by silence. Okay, let's suppose that that we have this symbol here. Okay, we have A and B. A and B. A, he has what? A has recently constructed a building blocks. Let's say that it is in a high street. It is in a rather largely populated area, okay? And he wanted to grant a lease of one block of the building to B. This is A, okay? This is B. A had the blocks of buildings, and A granted a lease of a block of buildings to B. Okay, this is the lease. Okay, the lease. Let's say that it's a lease for 3 years. Okay, the thing is that B wanted to rent this block of building in order to run a mini supermarket, okay, mini mart supermarket. Because B expected to have some profit due to the fact that that this building was in a rather populated area, okay? So that means that he would make some profits. But the thing is that indeed the government wanted to have this land. The government has a plan to expropriate this land. So there was the expropriation plan. And the thing is that A, the lessor, knew very well that his buildings were covered by the government plan to expropriate the land. The buildings were covered by the government's expropriation plan. A knew this truth, but A did not reveal this one to B. Did A tell a lie? No lie. A did not tell me anything about this. A just knew this fact, and he kept this quiet. He kept this silence. Okay, he just kept quiet about this. Okay, so that you can see that this is just non-disclosure. Would A be liable to B in this case when B knew the truth? If B had known this from the beginning, B would not have taken this list at all. because it would not be worth, right? The intention of B's intention was to use this, this building for running a mini mart, a mini supermarket. Okay, when these buildings, when these blocks would be expropriated by the government, then B would have to, suffer some injury due to this, expropriation. Okay, so what does the law say about this? Right. If we look at the legal consequence embodied in the civil and commercial code, indeed in section 162, okay, you can see that 162 that provides also, for the legal consequence. 162 also talk about the Juristic Act like this becoming voidable as well if the other party, in this case B, can prove that if he had no truth, he would not have made the Juristic Act at all. Okay, according to section 162, in a bilateral Juristic Act, okay, one of the party in a bilateral Juristic Act, one of the parties intentional silence, again, in a bilateral juristic act, one of the parties intentional silence by failing to disclose a fact or quality which is not known to the other party amounts to fraud. See, if it is proved that, look at the proof, okay? If it is proved that in the absence of such silence, such Juristic Act would not have been made. So the wording of the law, okay, as used in section 162, seems to be quite broad. If B can prove that if he had known the truth about the expropriation plan, then he would not have taken the lease. In this case, the lease agreement could be voidable, right? The wording seems to be quite broad. From the example above, the lease is voidable, so that B can avoid the contract, i.e. the lease. But even though section 162 says so, but in practice, okay, as a matter of practice, this provision of law will apply only narrowly. If you look at decisions of the Supreme Court, okay, the court seems to apply section 162, the case of fraud by silence or non-disclosure, okay, only in special cases, only in special circumstances where non-disclosure could be, could be reasonably blamable. Right. That means that there should be, the quite large blameworthiness on the part of the non-disclosing party. If there exists no special circumstances revealing, such a great extent of blameworthiness of the non-disclosing party, then the court will normally not allow the other party to just rely on this fraud, the silence, okay, to just escape contractual obligation, right? We can see the example here. We can see the example of quite large blameworthiness on the non-disclosing party. In one case here, right, the case which was decided by the Supreme Court in 2001, it was the sale of a 5-story building from A to B. Okay, A and B, they made this contract for the sale of a 5-story building. Okay, and of course this building would be equipped with an underground parking area. At that time, this building was under construction. Okay, it was under construction. Okay, the building at that time. The building had not yet been finished yet. It was under construction, and at that time, A applied for permission for the construction of the building. Okay, even though the contract of sale. Even maybe the agreement, not the contract of sale, okay, an agreement to sell, สัญญาจะซื้อจะขาย even though an agreement to sell indicated that was the agreement to sell a 5-story building. In fact, A applied for permission for the construction of only 4-story building. You can see that the first respect of blameworthiness on the part of A, the seller here, is that he knew from the beginning that he had applied for permission for only a 4-story building, but the agreement to sell, okay, indicated that was the sale of the 5-story building. So this was the blameworthiness of the seller. The second aspect of blameworthiness on the part of the seller is this. The seller, he knew that in fact his building, okay, which was to be constructed, okay, it was located in an area covered by an official survey for expropriation. This means that the government has a plan to expropriate this land in this area, okay? A knew this truth, A knew this fact, but A, okay, did not tell this fact to B. In fact, A had also signed an acknowledgement with the authority that he waived any right to claim compensation for the expropriation, okay? Normally, when your land is expropriated by the government, okay, you are entitled to compensation. But in this case, A knew about this plan, the expropriation plan, okay. A did not tell anything to B, and also A had even signed the official acknowledgement that he would waive any right to claim compensation from the government. Right. So these two aspects of blameworthiness led to the court, okay, concluding that this fraud by silence amounted to fraud, and it would make this contract voidable. So in this case, the Supreme Court just held that this agreement to sell was voidable on the ground of fraud, indeed fraud by silence. Okay, in accordance with what is said in section 162. Okay, 162, right. If it, remember 162 say that the Juristic Act becomes voidable if it is proved that in the absence of such silence, such Juristic Act would not have been made. What I'm saying is that in this case, the Supreme Court held that this agreement to sale was voidable on the ground of fraud by silence, because the Supreme Court just considered that the seller they had such a large extent of blameworthiness. But if the party who knows the truth and does not reveal the truth to the other party does not have such an extent of blameworthiness, then the Supreme Court say that it is not the duty to tell the truth. If anyone knows some truth and does not reveal that fact, it is not that party duty to reveal. Okay, so that the non-disclosure will not constitute fraud and will not lead to the contract in question or the Juristic Act in question becoming voidable. Okay, we can see the example, indeed a very strange example from this case decided by the Supreme Court in 1989. A, the seller, and B, the buyer. In this case, A entered into an agreement to sell again, A entered into an agreement to sell the land to B, okay, and the land was covered by the government plans to build a road. That means that in the near future there would be the road. Now the land seems to be very isolated, okay, but in the near future, not too distant future, this land would have the road along the land, okay. You know that if you own this land, and if this land in the future, if it is next to the road to be built by the government, you will not sell the land, because when there is the road along the land, then your land will be worth much more, right? In this case, A, the seller, okay, the seller sold this land to B, to the buyer, and the one who knew the truth about, about the construction of the road by the government, it is the buyer. The buyer knew this, but the buyer kept quiet. The buyer just kept quiet, because if the buyer had told the seller about this, the seller would not have, sold the land to the buyer, right? So in this case, we have, non-disclosure, or we have silence on the part of the buyer. When the seller knew the truth about, the government plan to build the road, okay, the seller, okay, in this case A, no longer wanted to sell the land anymore. The seller no longer wanted to sell this land to B, right? And in fact, the seller wanted to return the deposit, but B refused to take the return. B said, no, I'm not going to, take back the deposit which I, have, paid to you. That means that A, okay. The seller, you will have to just sell this land to me. I'm not going to just return you the deposit. You, the seller, will have to be bound by this sale. Right. In this case, when the seller tried to claim that, the contract in question, the jurisdiction in question, i.e. the agreement to sell between the seller and buyer, would be voidable on the ground of fraud by silence. And here is what the Supreme Court said. The Supreme Court said that, well, in this case, the buyer, even though the buyer knew the truth about, the government plan to build the road along the land, it was not the duty of the buyer to tell or to reveal this fact to the seller. So according to the Supreme Court, the silence which constitutes fraud under section 124, that was the previous section. Okay, now 142 has now become section 162 of the current civil and commercial code. Okay, silence which constitutes fraud under section 124, which is 162 now, must be silenced in the circumstances where a party is obligated to disclose facts. And the Supreme Court said that in this case, okay, it is not the duty of the party to disclose them. That means that even though B, the buyer, knew the truth about the fact about, the government's plan to construct the road along this land, it is not the duty of the buyer to reveal. See, so you can see that if you compare, two cases decided by the Supreme Court, the first case and this case, both cases were concerned with what? Both cases were concerned with, the knowledge, the subsequent knowledge about the government plan, the plan to appropriate the land, or the plan to construct the road. Okay, in the previous case, the jurisdiction in question became voidable on the ground of silence, the fraud by silence, because the Supreme Court just noticed that, okay, the aspects of blameworthiness by the party who did not reveal the fact. Okay, but in this case, the Supreme Court did not find any special circumstances indicative of, the blameworthiness of the party who knew the truth and, who did not disclose this truth to the other party. The Supreme Court said that it is not the duty of the party okay, i.e. in this case the buyer, to disclose the facts, right? So in a way, the blameworthiness of the party who the party who did not review the facts seem to be none or too little, so that in this case, when the Supreme Court did not find special circumstances, okay, the circumstances of blameworthiness of the non-disclosing party, the Supreme Court did not apply Section 162. The Juristic Act between the parties, therefore, did not become voidable. Right. On this point, let me just tell you that with respect to with respect to fraud in the form of non-disclosure, in fact, we can see we can see the ideas at an international level. At an international level, we also have the unilateral principles of international commercial contracts 2016. I don't think you know what is it. Okay, I'll just let you know that the attempts have been made to do what? To just formulate a body of law which apply to international commercial contracts. So the scholars, leading scholars, and legal practitioners, okay, of the different continents in the world, they came together to think of the rules or principles of law which would apply to international commercial contracts, and they try to just put all the rules together, okay, so that these rules have now become the unilateral principles of international commercial contracts. Okay, you can see many provisions in these unilateral principles, okay, including the provision Articles 3.2.5 on fraud, which speaks on say of fraud by non-disclosure. With respect to fraud by non-disclosure, it will make make the contract. It will just lead to invalidity only when what? Only when, according to reasonable commercial standards of fair dealings, the party who knew the fact or the truth would have to review. So, okay, in order to determine whether or not party A, okay, who know the truth, is required by law to review that fact to the other party or not, we will have to consider whether or not, according to a reasonable commercial standards of fair dealings, okay, that party will have to review the truth or not. If, according to reasonable commercial standards of fair dealing, A, who knows some truth, does not need to review that truth or that fact to B, then non-disclosure by A will not entitle B to avoid the contract or the Juristic Act. Okay, and that's it. For rules of law regarding fraud. Okay, so I think that we run quite good timing. Okay, that means that we have to just end the lecture today. The next lecture will be on Monday, and it's going to be focused on some more situations involving the realization of will. We will talk about the principles of law on the jurors and mistake. Okay, so that is going to be covered by our lecture on Monday. For today, thank you very much for your attention. Okay, and have a good day. Thank you. Bye bye.